And to judicial matters, a Federal High Court sitting in Abuja has granted former commander of Force Intelligence Response Team, DCP Abba Kyari, 2 weeks bail after 27 months in detention. The 2 weeks bail is to allow the former supercop the opportunity to go home and conclude his mother's burial rites. The court subsequently set Friday, May the 31st, for determination of his bail application in trial over drug-related charges filed by the National Drug Law Enforcement Agency following his arrest over 2 years ago on February the 14th, 2022. Recall that in 2022, the Police Service Commission, that's the PSC, suspended Kyari and 2 senior police officers, Sunday Ubwa and James Bauer, named in a cocaine deal involving suspended Deputy Commissioner of Police. For more on this, we have joining us virtually Dr. Hassan. He's a lawyer, to look at the legal implication of all of this. Thank you so much for joining us. So let me start by asking you, because this has been on for 27 months, that's more than 2 years. For the first time, he's getting bail. Let me get your reaction to this.
Yes, it's a pleasure to be on your program. Actually, hello?
Please go ahead.
Yes. Considering the bail application that the 2 week bail pending is the former bail application for Mr. Abba Kyari, is within the just magnanimous position to grant it. We must equally commiserate with that situation, though it is not by right to be granted on compassionate ground that in that same right it is not within his right, but the judge magnanimously gave that respect just to allow him to bury the mom, and we must commiserate, irrespective of the fact that he has also done some good jobs. We have to also condemn those bad acts, which is undergoing trial for. And we cannot prejudice the outcome of the court, but at the same time, it's still presumed innocent until otherwise proven at the end of the trial. But be that as it may, his former bail application will be coming up for the 30th of May, and the court still has discretion without say grant that bail application or refuse the bail.
And when you look at the fact that this has dragged on for 27 months and the bail application actually will now be heard on May the 31st, one will wonder what's exactly going on? Why is it taking that long, 27 months, to even hear a bail application in the first place?
We are talking about capital offense here. Not all offenses are bailable, especially when capital offenses have gas, cocaine, and all the drug-related offenses and other crimes that are also aligned with those investigations within the period. So I believe the court has their reason, and the investigation is still ongoing. So the NDLEA has the onus of why they need to keep him, and I'm sure is to unravel and also further on their investigation and also nip in the bud. And you could admit that there have been a lot of achievement within that same line. But we just have to acknowledge that it is within the confines of the law, of the rule of law. There is no violation of process. Everything is within the law. In as much as there has been an application, it is within the discretion of the judge. The judge can refuse the bail. It's not his right, depending on the risk factor or the magnanimity of the crime committed. But as far as we are still concerned, it's presumed innocent until proven otherwise at the end of trial.
Thank you so much for your time. Always a pleasure to have you on, lawyer Dr. Hassan.
Well, thank you very much. I will commiserate with his mother. Thank you.